1 and 34. And I'll note the court has given proposed instructions. What you said, Ms. Beatty, is the state accepting them as the court's drafted them at this point? Is that where the state stands?
That is correct, Your Honor.
Okay, thanks for clarifying. On those instructions on conspiracy then, Mr. Pryor, 29, 31, and 34, I don't believe the defense had an objection in the informal conference. I think the state had a concern. Is the defense going to approve instructions 29, 31, and 34 the way the state's or the court has proposed them?
Yes, Your Honor.
Okay, so I'll take those off the list. 29, 31, and 34 will all be provided to the jurors as the court gave in its proposed instructions. So that leaves maybe just inefficiency here again. We could move on to 17, which is the list of exhibits that are said to be demonstrative or illustrative. We have a numbered list there, and then I'll note we also went through exhibits on the record earlier today. Has the state been able to review those exhibits that are listed in instruction 17?
Yes, Your Honor.
Does the state agree that what's listed there is accurate of those exhibits that would be demonstrative or illustrative?
Yes, Your Honor.
Okay, Mr. Pryor, have you been able to review that list also after our exhibit conference?
Yes, Judge. And then the only one would be the defense exhibit that was demonstrative would need to be added.
And which number was that?
I believe that was 137, if I recall, Judge. I'll go back.
139? 8? We may have a note that's 138. Let's confirm.
I believe it's 138, Judge.
138, which is geofence evidence.
Yes, Judge.
Okay, so defense exhibit 138 would be included in the list. Does the state have any objection to adding that?
No, Your Honor. Thank you.
Okay, then where our instruction says defense's exhibits and it didn't list any, we will include 138, modify that instruction accordingly. All right. Let's talk about proposed jury instruction number 5. And I've got some comments of my own as we get started. So jury instruction number 5 is a standard instruction included in all criminal cases, which is an instruction about what is reasonable doubt. So it's a very seminal instruction. In this case, the court has given the instruction already on multiple occasions to the jurors, and it's also been referenced on occasion, both in voir dire and in some argument. The court received a notice through an order of the Idaho Supreme Court that as of May 22nd, so 6 days ago, the Supreme Court has now issued a new approved 103 reasonable doubt instruction, which is different than the instruction that's been provided. So I am going to hear some argument on whether or not we continue with the instruction already given or use the new approved instruction. And then again, I'm probably going to have some additional comments about where we go with that. But so I'll note we use the instruction that's been given for decades in Idaho and with probably nearly all criminal cases, but it's changed now. So changed as of 6 days ago. Very challenging timing for the court to have this happen mid-trial, but this is where we are, and we're going to discuss the issue because the order of the Supreme Court requires this to be considered effective as of last Thursday. So what is the state's position as it relates to instruction number 5, which mirrors the instruction already given to the jury and which I'll refer to as the old Idaho 103 reasonable doubt instruction?
Your Honor, the state believes that the jury should still be given the old reasonable doubt instruction. I am aware of the court's order on May 22nd. I would note that at the end of that order, the court actually orders that the order be published for 3 consecutive weeks on the Idaho State Bar website and in its weekly e-bulletin. I think that 3-week notice period within the order itself shows that the court is contemplating that it might not be used immediately. And I think additionally, we're in a position where we're choosing between giving the jury 2 different instructions on reasonable doubt, and basically changing it midstream versus just sticking with the one instruction that has been repeatedly upheld as a correct statement of the law on appeal. I think it would be the lesser evil to essentially, I mean, we're caught between a rock and a hard place here, but I think it would be the lesser evil to just give them the same consistent jury instruction that has been upheld as a correct statement of law. And I think that would create potentially less issues than trying to instruct them on an entirely new instruction after they've already listened to all of this evidence with the old instruction at the forefront of their minds. Thank you, Your Honor.
All right, thank you, Ms. Beatty. Mr. Pryor, where does the defense stand as it relates to the Supreme Court order that there's a new reasonable doubt jury instruction in Idaho?
And Judge, in response to Ms. Beatty's comment about the 3 weeks, that's a publishing requirement that they're just trying to comply with. I would hardly guess that they would consider changing the language after the work that they've put through. The issue I have, Judge, is that when you read what the instruction is from the Supreme Court, and this is supposed to be applied now, it's very similar to the instruction that was going to be given by the court before this came out. In fact, it says first, the state has the burden of proving the defendant guilty. That's not a surprise or a change to the jury. The state has the burden throughout the trial. Again, that's not a change to anything that's been stated to the jury. The defendant is never required to prove his or her innocence, nor does the defendant ever have to prove any evidence at all. Again, that's being provided to the jury, and they're aware of that. Then secondly, the state must prove the crime beyond a reasonable doubt. Again, that's not a surprise or a change. The change comes in, Judge, is when you go down under the column dated second, where it says proof beyond a reasonable doubt is proof that leaves you firmly convinced the defendant is guilty. It is not required the state prove the defendant's guilt beyond all possible doubt. Now, that's really the only change. And as I noted earlier in our conference, Judge, it really defines what reasonable doubt is and defines what the respective responsibilities of the party that each of the parties have. And through the 25 to 30 years I've been doing this, Judge, that's always been a difficult point. How do you define to a jury what reasonable doubt is? Now, again, the rest of the paragraph basically touches on very carefully about what is already going to be instructed to the jury. So all I'm asking to do is to include that explanatory language that says basically, listen, the state of Idaho has to prove firmly convinced that the defendant is guilty. And then at that point, it's not all possible doubt. That's a 2-sentence explanation that's added to what the jurors have already been instructed to. So to suggest that it's going to throw them off or make things more difficult, that's just not true. What it's going to do is provide them basically a definition, which I think in the wisdom of our Supreme Court, they realize that what we need and what we badly need is a specific definition of what reasonable doubt is. And in the past, yes, I spoke from many, many years ago when it was considered an abiding conviction to a moral certainty, and then it went to what it is now. And then this new change basically further clarifies what the definition is. And I would encourage the court to adopt this. I think that I disagree with Ms. Beatty wholeheartedly. I think that the Supreme Court put the time in to implement this new explanation, and I think we ought to adopt that. And I think they took the careful care to use what the old definition, the positives of the old definition, and maybe enhance it just a little bit. And then this enhancement really, quite frankly, just provides a more distinct and direct explanation of what reasonable doubt's all about. And I think it's important, given the magnitude of this case and the consequences of this case, that we use the Supreme Court's updated version of what reasonable doubt should be defined as.
All right, thanks for the argument, Mr. Pryor. Um, the court's been mulling this over since the order came out last Thursday. And I'll note also, I took the extra precaution of immediately advising counsel through an email to both sides that we had new instructions now that may or may not be required to be implemented in this case. The court notes that a few things here procedurally. We started with voir dire back in late March in this case. And during voir dire, when the jurors filled out their questionnaires, I think was one of the first references to this reasonable doubt instruction. The jurors heard instruction then. They also heard for sure there was reference to the instruction on April 20th in this case when they actually got the instruction, what I'll call the old 103 instruction. And I'll note the old 103 instruction, as I mentioned, has been in effect in Idaho for decades. There's a case, State versus Sheehan, 139 Idaho 2003, that discusses the old 103. And it says trial court judges are encouraged to use ICG 103 verbatim to avoid unnecessary appeals and controversy by utilizing the instruction that has an accepted history defining the burden the state bears. So even 21 years ago, Supreme Court said there was a accepted history of that instruction adequately defining the burden. There's also a case, Victor versus Nebraska, which was included in the old ICG comment section, which has been removed in the new instruction. And that is a reference that says in Victor v. Nebraska 511 US 1, 1994, the court held that any reasonable doubt instruction must, one, convey to the jury that it must consider only the evidence, and two, properly state the government's burden of proof. And then there's some additional citations. So I've gone back over that procedural history, and typically this court always tries to just use approved criminal jury instructions or civil instructions, depending on the case being tried. And a few other things. Then the order does state that the new instructions are effective immediately. It also says that it is recommended that whenever it says it is recommended that whenever the Idaho criminal jury instructions or the Idaho death penalty criminal jury instructions contain an instruction applicable to a case and the trial judge determines that the jury should be instructed on that subject, the judge should use the instruction contained in the most current Idaho criminal jury instructions and the Idaho death penalty criminal jury instructions, unless the judge finds that a different instruction would more adequately, accurately, or clearly state the law. So there's some exception there. And without going into an analysis of which instruction is better, the practical implication here is this is an instruction that's already been given to this jury on multiple occasions. And I have really considered the argument of the defense that maybe this doesn't change things. It adds some further clarification. Whether it does or not, it's very problematic to me to consider that the jury already got an instruction and then comes back just on the verge of deliberation and here's a different instruction. And the problem there is potentially wondering if that could serve to confuse them, if they took notes or adequate or could recall the first instruction, wondering why it's now different at this stage of the proceedings when we're still at the guilt phase. I'll also note that when there's case law out there that discrepancies in instructions becomes problematic. It might be difficult to know which instruction jurors relied on in making a decision. And this, of course, is perhaps the most important instruction as it defines the state's burden. So really, for just the practical purpose of keeping this jury not confused and not submitting to them a new and different instruction than they've already heard on multiple occasions, because this trial's already been going before this new instruction was implemented, I am going to give what I'll refer to as the old jury instruction 103. And I should say, give it again to the jurors. They've already heard it multiple times. And the one that we've included in our proposed instructions mirrors that they've already been read. I am going to provide that, finding that under the Victor versus Nebraska standard, it still adequately conveys to the jury that it must consider only the evidence and properly states the government's burden of proof. And also, while the new instruction may be better, finding that the Sheehan language that this instruction we've got has an accepted history of defining the burden in the state doesn't mean it's now an improper instruction. Maybe it's just not as good as the new instruction, but it, I think, has a real risk of potentially confusing jurors and confusing the record potentially on appeal about which standard they then employed, getting two separate instructions during trial. So with all that said, the court is going to provide instruction number 5 and overrule the objection of the defense on that particular instruction. All right, the next instruction we're going to take up then is number 14. And Ms. Beatty, you had some comments on 14.
Yes, Your Honor. In number 3, actually, I take that back. So underneath, certain things you have heard or seen are not evidence, including, I'm just looking at number 2, testimony that has been excluded or stricken, or which you have been instructed not to disregard, or which you have been instructed to disregard. We are just looking to add the words and or questions. So testimony and or questions that have been excluded or stricken.
All right, response, Mr. Pryor.
I don't think there's a need to put in the words question, Judge. It's testimony. It's in general. Testimony is broad enough that I think it's unnecessary.
All right, I've considered that request from the state to modify instruction number 14, subpart 3 of the instruction, subsection 2 currently reads, certain things you have heard or seen are not evidence, including testimony that has been excluded or stricken. State requests that questions be added to that language, given the nature of, well, not the nature, but just the extent and number of times the court sustained certain objections throughout the trial in the form of questions and was requested to strike the question, not necessarily the testimony. The court does find that this would be a proper instruction to clarify to the jurors that they do not consider what may have been perceived to be testimony because it was coming out and while a witness was on the stand, but was in fact a sustained objection on the record to a question itself. And the court did expressly strike or grant motions to strike questions that came up in witness testimony. So I am going to add that modification, and it will read under part 2, testimony or questions that have been excluded or stricken. And we'll put that as part of 14. Counsel, I think that covers then the jury instructions we had. So to recap, I've made those rulings. With those rulings now made, does the state have any further objections, or does the state approve the instructions with the court's new ruling?
Your Honor, the state approves them.
All right. And Mr. Pryor, I know I overruled a couple of your objections, so I'll ask that a different way, but the list I wrote or went through in the beginning, is that still accurate in your mind?
Yes, Judge.
Okay, and despite a couple of rulings against your request there, is there anything else you think needs to be addressed in the jury instructions?
No, Your Honor.
Okay, well, thanks all for helping us get these prepared. Scheduling then, we're going to get these done and distributed to the parties by tomorrow morning. You'll have them. We'll have the copies prepared for the jurors. We're going to start with the court reading the instructions at 10 o'clock a.m. and then closings will take place. Does that schedule work for the state?
It does, Your Honor.
Does that work for the defense?
And Judge, I missed the part. We're going to have copies when?
Well, we'll get the final copies of the instructions. I don't know that we'll get those to you this afternoon. We'll have those to you ready though in the morning, well before 10 o'clock.
Okay.
I would say they would be ready tomorrow morning, probably by 8:30.
Okay, that would be perfect. Thank you, Judge.
Okay, we'll get those. Thanks, counsel, for all the hard work today. Anything
you,
else
Honor.
before we go off the record?
No, thank you, Your Honor.
Nothing, Your Honor. Thank you.
Not on the record, Your Honor, but the state was wondering if we could meet with the court and counsel just very briefly on some scheduling issues.
All right, we'll take up a sidebar then before the court recesses. So we're done with the hearing then, off the record, and I'll talk to counsel then off the record. Thank you.